Wise of the 14th Court of Appeals here in Houston for this week's episode of the FCPA Compliance and Ethics Report. Judge Wise has graciously agreed to give us some time from his very busy schedule to visit with me and you all on a couple of topics that I've had a lot of interest in as a corporate lawyer and now as an FCPA practitioner. So with that introduction, Ken, thanks a lot for coming on the show. I really appreciate it. And could you tell the folks how you got to be on the Court of Appeals here on the 14th Court?
Sure. Well, thanks for having me today. It's always fun to be able to do these kinds of things. Stuck in the reading and writing that an appellate judge has to do all day, it's nice to get out of the office, so to speak. I was a trial judge for 10 years. Actually, before that, I practiced law for 8 years with a firm now known as Locke, Lord, Bissell, and Liddell, but was Liddell, Sapp, Sibley, Hill, and Laboon. I was appointed to the District Court bench, Civil District Court, the 152nd District Court in 2002. I went off the bench in 2009. I came back on the bench by appointment in 2011 for 2 years. So I did 2 different stints in the Civil District Courts as a trial judge for a total of about 10 years, and then was appointed last fall to the Court of Appeals.
Many of our listeners are not going to be from the great state of Texas, so they may not understand the split in civil and criminal courts here. Could you explain that for us?
Sure. Well, in Harris County, where Houston is, we have 59 district courts, which is approximately 12 or 13% of the entire state judiciary sitting in Harris County because we have such a volume. And so we split the district courts, which in Texas, a district court is the state trial court. We split our jurisdiction into civil, criminal, family, and juvenile because the dockets are so big. It enables us to have judges with experience in those areas presiding over those courts, which makes it more efficient. Plus just the sheer volume of cases and the priority that has to be given to certain types of cases. If we had all the cases in the same court, nothing would ever get done.
And when you say you were appointed, who made your appointment?
Governor Rick Perry appointed me both times, well, all 3 times now.
And after appointment, you are required to stand for election?
Yes, in Texas, judges are elected in partisan elections like any other political office. And so when you're appointed, you have to run in the next general election, whether that's for an unexpired portion of a term or for a full term. And so I've now run 4 elections and am 3-1.
And in addition to being our first justice on the podcast, I think it's safe to say you're our first Aggie. So could you tell us
start somewhere.
Tell us about that.
Well, I went to Texas A&M for undergraduate school, was actually on the rodeo team for 2 years, which is a little bit unusual for a judge, but I think the calf roping and steer wrestling has paid off in the judiciary.
Well, maybe we could end today's session with our thoughts on the Texans drafting Johnny Football.
Well, that's a minefield.
All right. What I wanted to visit with you about are a couple of areas, or maybe 3 areas, in the compliance and ethics world that I think can draw lessons from the trial lawyer and court of appeals world, at least on the civil side. The first is in contract interpretation, and I say that because the Department of Justice has specified certain contractual terms, they call them compliance terms and conditions, be appended to all commercial agreements involving third parties such as agents, resellers, distributors, etc. Both of us have as practiced civil law in the great state of Texas, and indemnities are something that we are both familiar with because it's a big part of any commercial practice here in Texas, and indemnities are part of these commercial terms and conditions. But what I really wanted to see if I could get some insight on is how does a trial judge view a contractual interpretation case, and then how does a court of appeals judge do it? Kind of a further background, it was my observation in the corporate world that many commercial lawyers who were drafting contracts didn't really understand who would be the ultimate trier of fact, or the ultimate arbiter, or the ultimate jury, or whoever might make the final decision if a contract went into dispute. Can you share with us some of your observations from the trial bench and your Court of Appeals experience?
Yeah, let me start with your last point about drafting contracts with an eye toward who's going to be interpreting that contract. You know, it seems to me that contracts serve 2 purposes, two big purposes in the commercial world. First, and hopefully the only one, is to give the parties guidance as to what they're supposed to be doing to make the deal work. That's what we anticipate happening in every commercial transaction. But the other and sometimes unfortunate thing is to govern what happens if somebody doesn't do what they've agreed to do. And so the ultimate reader of that contract is really going to be a judge or a jury. And so I think it's important to think about, when you're drafting those contracts, think about it in the breach, so to speak, and who's going to be reading that contract. If it's a judge has read a contract before, and judges are restricted, at least in theory, good judges are, by principles of contract interpretation that have become part of our common law. And so that's a little more predictable. Juries are typically not going to be lawyers, and they may or may not, any individual juror may or may not have ever read a contract before. Very few jurors are going to have ever read a multi-page, small print, very detailed, complex contract governing a commercial transaction. They're not going to understand the deal. They're not going to understand sort of the flip side of what you've asked about, which is what were the parties thinking when they drafted the contract? What was the intent? An understanding of the context of the deal, which is often important. And so you've got to be more clear than lawyers tend to be, because the trial lawyer is going to have to explain all that to the jurors. And so I think that if you do draft your contracts with an eye toward the unfortunate circumstance of having to present it to laymen and explain it, perhaps that would result in some clearer language.
One of the things that probably a lot of lawyers, in addition to a lot of lay people, don't understand is the role of parole evidence. Can you explain that under Texas law?
Yeah, generally, parole evidence is evidence outside what we call the four corners of the agreement. And so the four corners of the agreement are what's written on the document, and perhaps an appendix, perhaps an amendment, etc. And so if it isn't in the document, then trying to introduce evidence that explains something in the document is trying to introduce parole evidence. As a general rule, parole evidence is not admissible to interpret the contract. Parole evidence sometimes is admissible to give flavor to the deal, so to speak. I won't say intent of the parties as far as what the contract means, but intent of the parties as to what they were trying to accomplish sometimes comes in, or as I like to think of it, context. And so you can admit it for that purpose. So it's a very tricky area of the law. It always comes up in a trial. And so I think the lesson that you take is when you're sitting around the table agreeing to contract terms with the other side, you don't nod your head and say, well, we all know what that means, because you're not going to be able to say that to somebody. You're going to have to read the contract.
I did a lot of international transactions. The FCPA, of course, is a Foreign Corrupt Practices Act, where it's focusing on actions of a U.S. company outside of the United States, which means you're going to have a contract outside of the United States. Typically, those are not negotiated face-to-face. They are occasionally, but usually it's via email. What is the role of email communications between the lawyers, for instance? Could that be parole evidence?
Well, I didn't know there was going to be a test. No, I think, yes, certainly would be parole evidence. Communications between the lawyers would not be privileged, but it could be parole evidence if it's, I suppose, drafts of a certain paragraph, perhaps. If it's a discussion of the party's intent behind the deal, or some sort of reference to a circumstance that give rise to this issue in the contract, then that might come in. But as a trial judge, I generally always just thought of it in the context of, if the contract addresses it, then you're confined to the contract. But if you need a little flavor or a little context, then that piece of evidence will probably come in. And it really is a document by document inquiry. And there are some hard fought battles during a trial over whether this email or that email is going to come in, because of a perception that, which I think is largely correct, that if it is on paper, jurors tend to take it a little more seriously. And so some of those battles are worth fighting, for sure.
And that's really leads to the question I wanted to ask you about jurors in contract interpretation. Certainly as a lawyer, I was comfortable having a judge read a contract. I believe that a judge understood his obligations to stay within the four corners of the contract, except, as you have noted, and I was comfortable if parole evidence came in, because he would give it the weight it was appropriate. My comfort level perhaps was not as high with a jury. But what have you seen work with a jury, not work with a jury? I recognize you as a trial judge would have the ability to admit or not admit evidence, but once it's in, it's in.
Yeah.
So,
Well, when you say work with a jury, what do you think is
I'm sorry.
persuasive? or-
Yes. Be persuasive to a
Well,
jury.
I would say jurors tend, you need to think of persuading juries, and I'm moving into my role as an adjunct trial advocacy professor, which you're very familiar with. Um, you know, juries want people to do the right thing. They wanted people to do what they said they would do. And so, and juries react very favorably if they think that people have acted as the juror would expect them to act. So you start with the contract, and an honest misinterpretation or miscommunication between parties is not going to probably not going to result in liability if everybody is trying to make the deal work, or will result in a verdict one way or the other that neither side will be upset about because they're probably in a lawsuit just to determine what they need to be doing. In other words, they don't want to be out of business with each other. They just need somebody, some vehicle to determine what they're supposed to be doing. And in our system in America and in Texas, that's a lawsuit. And so it's not quite a friendly situation, but it is a way to work out commercial disputes. The other thing, though, is if they think that somebody is trying to shade the deal or circumstances have changed and it's obviously not a good deal for one party and that party is the one that's trying to really weasel with the language of the contract and get hyper technical and all of that, jurors tend not to favor that sort of thing. So I don't know if that answers your question.
No, that's a really interesting observation.
Jurors really want people to do kind of their view of the right thing.
Do what they say they were going to
And they don't mind, something that surprised me on my years on the trial bench, jurors don't mind conflict, and they don't mind honest, somebody trying to do the best they can for their business. But if you sign a written contract, jurors love written contracts. They really love written contracts. The first question in a case that involved a representation of some sort, oral representation or an oral contract, the first question I would get when interviewing jurors after the verdict is, why didn't they write it down? And so they love written contracts. So when you write one, you're going to have to live with it.
Has your role as a justice on the Court of Appeals in a contract dispute case changed, and if so, how?
Well, it has changed as my role in every case has changed.
Okay.
The Court of Appeals is such a different environment than the trial court. In the trial court, I'm making a lot of decisions every day, making them quickly and with a view toward what's going to happen in the future. For example, if there's a discovery dispute, I might be working out a solution with the parties, guided by the rules, but really focused on, what's most efficient for the case, what's going to keep our trial on track, what's going to not force somebody to waste somebody's client to waste a bunch of money. As we all know, litigation is extremely expensive these days. And all of the decisions with an eye toward the future and protecting the process and protecting the trial and then protecting the verdict. In the Court of Appeals, all of that's been done. And so I get a package, for lack of a better description, with the record and the transcript and the evidence, and I'm looking backwards. The issues are fewer, they're narrow, they're issues of law, and I am confined to what's in that package. I can't ponder the practicalities or anything like that I might think about on the district court because I don't have as much flexibility. I've got a defined standard of review, and I've got a set of facts, and they are what they are. I can't change them. I can't ask any questions about new facts. I have to just take it as it comes to me. So that's starting at the end and looking backwards is a very different perspective.
Now, here in Texas, every litigant has a right of appeal
Right.
to the Court of Appeals. The Supreme Court is a discretionary appeal. You have to ask the court.
Hmm.
So does that change the sort of mix of cases you might get? And tell us about having criminal cases now.
Well, a funny story I have told around town, so I will tell here. My first oral argument was a criminal case, and so having been in the civil world, I had a little bit of criminal law experience in a law school in a clinic, but that was it. And so my first oral argument, I was furiously scribbling notes, which weren't notes, but rather terms that I needed to go look up because I hadn't heard them in 20 years. So I've had to get back into that area of the law for sure. But the mix of cases is very interesting because not every civil case is appealed. Every criminal conviction almost is appealed. But the civil cases, you get some very complex legal issues because those are issues that are ruled upon in the trial court, are a very limited and small, though important piece of the case, and the case goes on to conclusion. There's a phrase that we used in the trial court a lot, well, we can just let the appeals court decide that one. Right. So you needed to keep making rulings so that the case moved forward through the system. At the appellate level, that's where you're really going to drill down on those complex legal issues. So what I have discovered is that while I have all the time in the world to research and decide them, thank goodness, I also get some very significant, complex legal issues. And the other part of it is on the appellate court, you've got to think about the effect of your decision because unlike a district court, I have to explain my decision. I write an opinion, which in a complex case will probably get published forever. And so you got to be sure that lawyers that read that or the next case involving that issue, that this particular opinion helps or at least does no harm to the issue. And that's a consideration that I never had to worry about on the district court.
I'd like to turn now to a different issue from the FCPA world, and that's investigations. Internal investigations, external investigations. Would preface it with, in my former life as a trial lawyer, I handled lots of cases which were catastrophic personal injury events or property damage cases. And they're usually involving petrochemical plants or in the energy industry, where there had been a pretty extensive post-accident investigation, generally by the parties, generally done by non-lawyers. The companies were pretty good at those, and they taught their accident investigators to record facts, don't record opinions. The few times I went to trial in one of those cases, those were powerful pieces of evidence because of that maxim to record facts and not give opinions. And jurors tended to view if a company assigned blame to themselves or others, that was worth some weight and would give that some credibility. In the FCPA world, there's sort of this ongoing debate, though, about who should do an investigation. So typically a company could find out an issue via an internal reporting mechanism, a hotline, or other government inquiry. Unfortunately, there have been examples, companies find out about FCPA issues in the front page of the New York Times, and then they have to scramble a little bit. But there's, like I said, an internal debate on who should do the investigation. And the question I wanted to pose to you is, not from sort of the DOJ perspective, but from really a trial judge perspective or a justice perspective on the Court of Appeals. What do you find persuasive from an investigation?
Well, the persuasive aspect of it would occur probably at the trial court level, and it comes down to credibility. Jurors are very astute at picking up economic incentives, which are not always financial. Sometimes an incentive would be somebody to keep their job or something like that. So I would think that in a personal injury context, you're comparing fault. And so there's room to move. If a company says, well, we could have done this better or could have done that better, I think you're right. Jurors would say, well, at least they're honest or appear to be honest. And that doesn't really affect the verdict all that much. It can be helpful to accept blame if there's blame to accept. In an FCPA context, I would imagine that's a little more dangerous. You don't want to accept blame, and there's less room for compromise, I suppose. You've either violated it or you haven't. So the credibility of the investigation changes because the people, internal people, might be viewed as more apt to be protecting themselves or others. And so I would speculate in speculation, in what's in a juror's mind, but based on my experience with juries and their general attitude, I think they would want a third party to come in and say, yay or nay. At least they would view it as a little more credible.
One of the other issues in the investigative realm of FCPA is whether you need specialized investigative counsel. Kind of having grown up in the trial lawyer world in Texas and being the son of a naval officer, my dad's maxim was once an officer, always an officer. That led to once a lawyer, always a lawyer. And if you're a trial lawyer, you're supposed to be able to take a deposition. You're supposed to be able to do an investigation. And in the firms that we both worked at, that was pretty much true. But in the FCPA world, there seems to be a thought that you really need sort of specialized counsel. Do you ever come up in a situation either on the trial bench or the appellate bench where you've seen specialized counsel been able to bring some additional level of credibility to an investigation?
You know, I've got to say I haven't seen it just because at the trial, those specialized counsel wouldn't be testifying probably because it's still a privileged situation. Mm-hmm. Internally, any sealing off of those kinds of matters that you could accomplish reasonably probably would just give that much more of an air of independence to the situation. Now, as far as who does the investigation, you know, the more you know about a particular area of the law, perhaps the better questions you're going to be able to ask, or red flags might be red for you and not as red for somebody that doesn't have that experience. And so that would argue certainly for a specialist.
I'd like to turn now to really a completely different area, and that involves the system we have in Texas of electing judges. And part of FCPA compliance is having an ethical business and doing business ethically. And a lot of people have raised questions about, can you have an ethical system where you elect judges and you have to run a campaign and you have to depend on campaign contributions. So I'm one of the people that's in favor of electing judges. I think that they're part of our government, so that they should be elected, or at least the people should have a right to speak at some periods of time. I recognize others have other views, and other states have other systems that work for those states. Once again, a long-winded way of introducing the topic of ethics. And what I wanted to visit with you about is what are your obligations under the laws of the state of Texas as a judge along those lines?
Wow, that's complicated. Judges have such a unique role in our system of government. You know, the judiciary is supposed to be as independent from the other parts of the government as possible. Anything you do that makes judges like other officials in the government lessens that independence, and that's a problem when it comes to partisan elections. And I say partisan elections as opposed to perhaps a retention election system, which many states, and some of your viewers probably are in those states, where judges might be appointed and then an up or down vote on that judge's performance is taken. Because the problem with partisan elections, and I've been on the good end of this and the bad end of this, is it doesn't matter what your record is. You can be beaten, and if you are beaten and you're doing a good job, you probably are beaten in a partisan swing, where the top of the ticket of the other party sweeps all the judges of one party out. Well, that cannot be a good result.
Right.
Because good judges and bad judges are swept out, and the voters don't necessarily know what they're doing. And if asked, because I've asked them, would probably not want that to occur. And plus it just bogs down, especially the civil litigation system. Mm-hmm. But electing judges in partisan elections in Texas goes back to Reconstruction. And there have been a lot of efforts to change it, and I don't see it changing in my lifetime. It is our system, it is our law, and I fully support it. And I understand the importance of having accountability to the people, and I enjoy that opportunity. I mean, I love the opportunity to go explain the role of the judiciary. The problem that we have as voters is you do have to explain the role of the judiciary. They don't go into the voting booth understanding it, researching it, and making decisions, voting decisions based on it. So it's difficult. And as a judge, having to run for office, when I was appointed in 2002 the first time, I had to run right away. I had to be up for election over opposition in 5 months. And so I was running for office immediately, as well as learning to be a judge. Very difficult, because you have a fundraiser on your political side so you can keep your job, and then you come into court to do your job, and there before you are contributors. Well, that's not good. That does not give the public a lot of confidence in the system. And so, how do you fix it? I don't know. But as a sitting judge, you have a fork in the road very early in your career, and it's when contributors are in front of you, or when a contributor is on one side and a non-contributor is on the other. And that's a fork in the road. And if you don't take the right fork then, it's going to be tough. And vast majority of judges in Texas take the right fork.
And I would certainly agree with that. As a practicing lawyer, I made contributions. I was up against lawyers who made similar or more greater contributions, and I felt like that had no effect on rulings by judges. I think our contributions were to keep what we thought were good judges in place. I certainly recognize the point you raised about partisan elections. We could probably take 2008 and 2010 as the best recent examples, but it was bloodbaths in the 80s when Mark White and Governor Clements were swapping out, and the top of the ticket just changed. Yeah. We lost some really good judges both times for both parties, and that's something that I was trying to think of the last time there had been a serious effort at reform driving down here, and I really think it was John Hill's effort in the late 80s. I hold out a little more hope than you. I think it will happen in my lifetime, and that means your lifetime, hopefully.
Well, you may outlive me.
And you also correctly note that that's been our system since Reconstruction, and some things we're loath to change here in Texas, and perhaps with good reason. But I think a considered debate on that would be welcomed by the public and in the legislature. And I hope that dialogue will continue, because you're right. Just looking at 2008 and 2010, it's just we lost way too many good judges in that. But most judges, I think, do exactly what you said. They come to a fork in the road, and once they take the right fork, everybody knows it.
Yeah.
And so I've never found it to be a problem, and but it's something that you guys have to contend with, and under the system we have. So with that, I think we're near the end of our time, and I really appreciate you taking the time to visit with me. I have to tell you, I'm a huge Johnny football fan, and
well, as am I.
I'm lobbying the Texans to take him. I think it would be great. I think he'd put bodies in the seats out there.
For sure.
And I think that I should probably tell our viewers I did not go to Texas A&M. I went to that other place, but that I thought Johnny Football gave Texas A&M the best chance to win the national championship because he was such a talent.
It was an exciting time, for sure.
And he could do things that I've never seen even Vince Young do. Yeah. And I thought Vince was the best. So looks like the Texans have two more fans here who want them to draft Johnny Football. With that, once again, I'd like to thank you a lot for taking the time to visit with me from your very busy schedule. This is Tom Fox, and we look forward to visiting with you on our next episode.